Meaning of company. Company means a company incorporated under this act or under any previous company law. Features of a company. 1. Separate legal entity. When a company is registered, it is clothed with a legal personality. Almost same rights and powers as a human being. Company can own property, have bank account, raise loans, incur liabilities, and enter into contracts. Even members can contract with company, acquire right against it, or incur liability to it. For the debts of the company, only its creditors can sue it, and not its members. Shareholders are not private or joint owners of company's capital and assets, even though contributed by them. 2. Perpetual succession. Members may die or change, but the company goes on till it is wound up. Shares may change hands infinitely, but that does not affect the existence of the company. Company is an artificial person created by law. Law alone can bring an end to its life. Its existence is not affected by the death or insolvency of its members. 3. Limited liability. 1. Limited liability company. The liability of members limited to the extent of nominal value of shares held by them. Max liability, up to the unpaid value of shares. 2. Company limited by guarantee. Amount guaranteed by them, and that too only when the company goes into liquidation. 3. Unlimited company. The liability of its members is unlimited as well. 4. Artificial legal person. Company is created by a process other than natural birth. It is legal or judicial as it is created by law. It is a person since it is clothed with all the rights of an individual. The company being separate legal entity can own property, have banking account, raise loans, incur liabilities, and enter into contracts. Even members can contract, acquire right against it, or incur liability to it. It can sue and be sued in its own name. It can do everything which any natural person can do except be sent to jail, marry, or practice a learned profession. Hence, it is a legal person in its own sense. Company is an artificial person, hence it can act only through some human agency that is directors. 5. Common seal. Common seal is the official signature which is affixed by officers and employees on its every document. The Companies Amendment Act, 2015, has made the common seal optional. In case a company does not have common seal, authorization shall be made by 2 directors, or by a director and the company secretary. Wherever company has appointed company secretary. Corporate veil. Corporate veil refers to a legal concept whereby the company is identified separately from the members of the company. Due to this, members of a company are shielded from liability connected to the company's actions. Lifting of corporate veil. Where the courts ignore the company and concern themselves directly with the members or managers, the corporate veil may be said to have been lifted. Only in following circumstances, the courts are willing to lift the corporate veil. 1. Determine the character of company, that is to find out whether co-enemy or friend. Company does not have mind or conscience. Therefore, it cannot be a friend or foe. It may, however, be characterized as an enemy company, if its affairs are under the control of people of an enemy country. For this purpose, court may examine the character of persons who are really at the helm of affairs of the company. 2. To protect revenue or tax. Where corporate entity is used to evade or circumvent tax, court can disregard the corporate entity. 3. To avoid a legal obligation. Where the sole purpose for formation of company was to use it as a device to reduce the amount to be paid by way of bonus to workmen, Supreme Court upheld the piercing of the veil to look at real transaction. 4. Formation of subsidiaries to act as agents. Company sometimes regarded as an agent or trustee of its members, or of another company, and may therefore deemed to lost its individuality in favor of its principal. Here, the principal will be held liable for the acts of that company. 5. Company formed for fraud/improper conduct or to defeat law. Where device of incorporation is adopted for some illegal or improper purpose. Example, to defeat or circumvent law, defraud creditors, or avoid legal obligations. Classes of companies under the Act. On the basis of liability. 1. Company limited by shares. When liability of members of a company is limited by its memorandum of association to the unpaid amount on shares held by them, known as company limited by shares. Shareholders' separate property cannot be encompassed to meet the company's debt. Shareholders are not the co-owners of assets, even though contributed by them. Ownership of assets remains with the company because of its nature as a legal person. Rights and duties of a shareholder as co-owner is measured by his shareholdings. 2. Company limited by guarantee. Liability of its members limited to such amount as members may respectively undertake by memorandum to contribute to assets of company in the event of winding up. Members cannot be called upon to contribute beyond that stipulated sum. It does not raise its initial working funds from its members. This is useful only where no working funds are needed or where these funds can be held from other sources like donation, etc. Common features between guarantee company and company having share capital, legal personality and limited liability. Both have to state that members' liability is limited in their memorandum. Point of distinction is, guarantee company members may be called upon to discharge their liability only after commencement of winding up, but company limited by shares may be called upon to do so at any time, either during the company's lifetime or during its winding up. 3. Unlimited company. Company not having any limit on the liability of its members. Liability of a member ceases when he ceases to be a member. Liability extends to whole amount of the company's debts and liabilities. So long as the company is a going concern, the liability on the shares, unpaid amount, is the only liability which can be enforced by the company. Creditors can institute proceedings for winding up of the company for their claims. The official liquidator may call the members for their contribution, which can be unlimited. On the basis of members, 1. One-person company. One-person company as a company which has only one person as a member. It is a private limited company with minimum paid-up share capital as might be prescribed and having only one member. The only member can be the sole member and director of the company. Memorandum shall indicate the name of other person who shall, in the event of subscriber's death or his incapacity to contract, become the member of the company. Member may at any time can change the name of such other person by giving notice to the company, and the company shall intimate the same to registrar. Such change is not deemed to be an alteration of memorandum. Only a natural person who is an Indian citizen, whether resident in India or otherwise, shall be eligible to incorporate OPC, shall be a nominee for the sole member of a OPC. Resident in India, a person who has stayed in India for a period of not less than 120 days during the immediately preceding financial year. No person shall be eligible to incorporate more than one such company or become nominee in more than one such company. Clarification. The provision given above means you cannot be member in two such companies or nominee in two such companies at the same time. But at a same time, person can be a member of one such company and can be a nominee of another. No minor shall become member or nominee of such a company, or can hold share with beneficial interest. Such a company can't be incorporated or converted into a company for charitable objects, can be converted to private or public company. Such a company can't carry out non-banking financial investment activities, including investment in securities of any body corporate. 2. Private company. Means a company having minimum paid-up share capital prescribed, and which by its articles, 1. Restricts the right to transfer its shares. 2. Except in case of a one-person company, limits the number of its members to 200. 3. Prohibits any invitation to public to subscribe for any securities of the company. Provided that where two or more persons hold one or more shares in a company jointly, they shall be treated as a single member. Provided further that a. Persons who are in the employment of the company, and b. Persons who, having been formerly in the employment of the company, were members of the company while in that employment and have continued to be members after the employment ceased, shall not be included in the number of members. 3. Small company. Means a company other than a public company whose 1. Paid-up share capital does not exceed 10 crore rupees, and 2. Turnover, of which as per profit and loss account for the immediately preceding financial year does not exceed 100 crores rupees. Exceptions. This clause shall not apply to a. Holding company or a subsidiary company. b. A company formed for charitable objects. c. A company or body corporate governed by any special act. 4. Public company. Means a company which is not a private company and has minimum paid-up share capital as may be prescribed, provided that a company which is a subsidiary of a company shall be deemed to be public company even where such subsidiary company continues to be a private company in its articles, on the basis of control. 1. Holding and subsidiary companies. Holding company in relation to one or more other companies means a company of which such companies are subsidiary companies. Company includes body corporate. Subsidiary company in relation to any other company, that is to say the holding company, means a company in which the holding company 1. Controls the composition of the board of directors, or 2. Exercises or controls more than 1/2 of the total voting power either at its own or together with one or more of its subsidiary companies, provided holding company shall not have layers of subsidiaries beyond numbers as may be prescribed. 2. Associate company. Means a company in which that other company has a significant influence, but which is not a subsidiary of the company having such influence and includes a joint venture company. Significant influence means control of at least 20% of total voting power, or control of or participation in business decisions under an agreement. Joint venture means a joint arrangement whereby the parties that have joint control of the arrangement have rights to the net assets of the arrangement on the basis of access to capital. 1. Listed company. Company which has any of its securities listed on any recognized stock exchange, provided such class of companies which have listed or intend to list its securities in consultation with the Securities and Exchange Board of India shall not be considered as listed companies. 2. Unlisted company. Company other than listed company. Other companies. 1. Government company means any company in which not less than 51% of the paid-up share capital is held by central government, by any state government or governments, or partly by central and partly by one or more state governments, and includes subsidiary of such a government company. If shares are issued with differential voting rights, then paid-up share capital shall be construed as total voting power. No preference shares taken. 2. Foreign company. It means any company or body corporate incorporated outside India which has a place of business in India, whether by itself or through an agent, physically or through electronic mode, and conducts any business activity in India in any other manner. 3. Company for charitable objects deals with the formation of companies which are formed to promote the charitable objects and intends to apply its profit in promoting its objects and prohibiting the payment of any dividend to its members. Power of central government to issue the license. 1. The central government can register person or association of persons as a company with limited liability, without addition of words limited or private limited to its name, by issuing license on such conditions as it deems fit. 2. The registrar shall on application register such person or association of persons as a company under this section. 3. On registration, the company shall enjoy same privileges and obligations as of a limited company. Revocation of license. The central government may by order revoke the license of the company where the company contravenes any of the requirements or conditions subject to which a license issued, or where the affairs of the company are conducted fraudulently, or violative of the objects of the company, or prejudicial to public interest. On revocation, registrar shall put limited or private limited to its name. Before revocation, central government must give a written notice of its intention and opportunity of being heard. Order of the central government. Where a license is revoked, central government may in the public interest order to amalgamate with another company registered for similar charitable objects to form a single company or wound up. Penalty/punishment in contravention. Company, not less than 10 lakhs but may extend to 1 crore and director and every officer in default. Fine, not less than 25,000 but may extend to 25 lakhs. 4. Dormant company. Where a company is formed and registered under this Act for a future project, or to hold an asset or intellectual property, and has no significant accounting transaction, such a company or an inactive company may make an application to registrar for obtaining the status of a dormant company. Inactive company means a company which has not been carrying on any business or operation, or has not made any significant accounting transaction during the last 2 financial years, or has not filed financial statements and annual returns during the last 2 financial years. Significant accounting transaction means any transaction other than 1. Payment of fees by a company to the registrar. 2. Payments made by it to fulfill the requirements of this Act or any other law. 3. Allotment of shares to fulfill the requirements of this Act. And 4. Payments for maintenance of its office and records. 5. Needy companies. Means company which the central government may by notification in the official gazette declare to be a needy or mutual benefit society. These are created for cultivating the habit of thrift and savings amongst its members. 6. Public financial institutions. Following institutions are to be regarded as public financial institutions. 1. LIC of India, established under the Life Insurance Corporation Act, 1956. 2. Infrastructure Development Finance Company Limited. 3. Specified company referred to in the Unit Trust of India. 4. Institutions notified by the central government under Companies Act, 1956. 5. Institution notified by the central government in consultation with the Reserve Bank of India. No institution shall be so notified unless a. It has been established or constituted by or under any central or state act other than Companies Act 2013 or previous company laws, or b. Not less than 51% of paid-up share capital is held or controlled by central or by any state government or governments, or partly by central and partly by one or more state governments. Effect of memorandum and articles when registered. Memorandum and articles when registered shall bind the company and members as if they respectively had been signed an agreement to observe all provisions of the memorandum and articles of association. All monies payable by any member to company under the memorandum or articles of association shall be a debt due from him to company. Classification of capital. In relation to a company limited by shares, the word capital means share capital, or figure, in terms of rupees divided into shares of fixed amount. Contributions of persons to the common stock of company form the capital. 1. Nominal or authorized or capital. Means such capital as authorized by memorandum to be the maximum amount of share capital of the company. It is the sum with which it is to be registered, being maximum amount authorized to raise, and upon which stamp duty is paid. It is usually fixed estimated amount including working capital and reserve capital which company will need. 2. Issued capital. Means such capital as the company issues from time to time for subscription. It is the part of authorized capital offered by company for subscription, and includes the shares allotted for consideration other than cash. Schedule 3 makes it obligatory to disclose its issued capital in balance sheet. 3. Subscribed capital. Means such part of capital which is subscribed by the members of a company. It is the nominal amount of shares taken up by the public. 4. Called up capital. Such part of capital which has been called for payment on shares issued. It is the total amount called on the shares issued. 5. Paid up capital. Total amount paid or credited as paid up on shares issued. It is equal to called up capital less calls in arrears. Shares. Kinds of share capital. According to the provision, the share capital of a company limited by shares shall be of two kinds. 1. Equity share capital. Means all share capital which is not preference share capital. Types of equity share capital. Equity share capital with voting rights. Equity share capital with differential rights as to dividend, voting or otherwise. 2. Preference share capital. Means that part of the issued share capital of the company which carries or would carry a preferential right with respect to a. Payment of dividend, either as a fixed amount or amount calculated at a fixed rate, which may either be free or subject to income tax. And b. Repayment, in the case of a winding up or repayment of capital, of the amount of the share capital paid up or deemed to have been paid up whether or not there is a preferential right to the payment of any fixed premium or premium on any fixed scale, specified in the memorandum or articles of the company. Exception. In case of private company, this shall not apply where the memorandum and articles of association provides. Memorandum of Association. Memorandum is in fact its charter. It defines its constitution, scope of the powers of the company, and it is the very foundation on which the whole edifice of company is built. Object of registering a memorandum of association. A. It contains the object for which company is formed, identifies possible scope of its operations beyond which its actions cannot go. B. Enables shareholders, creditors, and all those who deal with company to know what its powers are and what activities it can engage in. Memorandum is a public document. Consequently, every person entering into a contract with company is presumed to have the knowledge of conditions contained therein. C. Shareholders must know the purposes for which his money can be used by the company and what risks he is taking in making the investment. Contents of the memorandum. 1. Name clause, in case of public limited company. Name of company ends with the last word, limited. Private limited company ends with the last words, private limited. One-person company, the words, one-person company, should be included below its name. Government company, name must end with the word limited. This clause is not applicable on companies formed for charitable objects. 2. Registered office clause. The state in which the registered office of the company is to be situated. 3. Object clause. Objects for which the company is proposed to be incorporated. If any company has changed its activities which are not reflected in its name, it shall change its name in line with activities within a period of 6 months from change of activities. 4. Liability clause. Liability of members, whether limited or unlimited, and also state. In case of company limited by shares, liability is limited to the amount unpaid. And, in case of company limited by guarantee, amount up to which each member undertakes to contribute to assets of company in the event of winding up while he is a member. 5. Capital clause. Amount of authorized capital divided into share of fixed amounts and the number of shares with the subscribers, indicated opposite their names, which shall not be less than 1 share. 6. Association clause. Details of subscribers to form company. Memorandum shall conclude with this clause. Every subscriber to the memorandum shall take at least 1 share, and shall write against his name the number of shares taken by him. 7. Succession clause. In the case of a one-person company, name of the person who, in the event of death of the subscriber, shall become the member of the company. Articles of Association. Articles of a company are its rules and regulations framed to manage its internal affairs. Articles play a part subsidiary to Memorandum of Association. It provides the mode and form in which the business of company is to be carried on. The document containing the Articles of Association is a business document. Hence, it has to be construed strictly. Articles are bylaws of company according to which director and other officers are required to perform their functions as regards to management, accounts, and audit. Contents of articles. 1. Contains regulations. Articles shall contain the regulations for management of company. 2. Inclusion of matters. also contain such matters as are prescribed under the rules. Also include additional matters as may be considered necessary for its management. 3. Contain provisions for entrenchment. Articles may contain provisions for entrenchment to the effect that specified provisions of the articles may be altered only if conditions or procedures which are more restrictive than special resolution are met or complied with. 4. Manner of inclusion of the entrenchment provision, made either on formation of a company or by an amendment in the articles agreed to by all the members in case of private company, and agreed by special resolution in case of public company. 5. Notice to the registrar of the entrenchment provision. Whether made on formation or by amendment, the company shall give notice to the registrar in the manner prescribed. 6. Forms of articles. Articles shall be specified in tables F, G, H, I, and J in Schedule 1. 7. Model articles. Company may adopt all or any of the regulations contained in the model articles applicable to such company. Doctrine of ultra vires. The meaning of the term ultra vires is simply beyond powers. The legal phrase ultra vires is applicable only to acts done in excess of the legal powers of the doers. This presupposes that the powers in their nature are limited. The impact of the doctrine of ultra vires is that a company can neither be sued on an ultra vires transaction, nor can it sue on it. Since the memorandum is a public document, it is open to public inspection. Therefore, when one deals with a company, one is deemed to know about the powers of the company. If in spite of this, one enters into a transaction which is ultra vires the company, he/she cannot enforce it against the company. The whole position regarding the doctrine of ultra vires can be summed up as 1. When an act is performed, which though legal in itself, is not authorized by object clause of the memorandum, it is said to be ultra vires the company, and hence null and void. 2. An act which is ultra vires, the company cannot be ratified even by the unanimous consent of all shareholders. 3. An act which is ultra vires the directors, but intra vires the company can be ratified by the members of the company by passing a resolution at a general meeting. 4. If an act is ultra vires the articles, it can be ratified by altering the articles by a special resolution at a general meeting. Doctrine of constructive notice. Any person can inspect, make a record, get a copy, or extracts of any document kept with registrar on payment of prescribed fee. Memorandum and articles of association, when registered, becomes public documents, hence available for inspection. It is therefore the duty of every person dealing with a company to inspect its documents and make sure that his contract is in conformity with their provisions. But whether a person reads them or not, it will be presumed that he have knowledge of the contents and also understood them in true perspective, all the documents. This kind of presumed/implied notice is called constructive notice. Thus, if a person enters into a contract which is beyond the powers of the company or outside the authority of directors, he cannot acquire any rights under the contract against company. Doctrine of indoor management/Turkwind rule. It is the exception to the doctrine of constructive notice. It does in no sense mean that outsiders are deemed to have notice of the internal affairs of the company. If an act is authorized by the articles or memorandum, an outsider is entitled to assume that all the detailed formalities for doing that act have been observed. Exceptions to the doctrine of indoor management. 1. Actual or constructive knowledge of irregularity. Rule does not protect any person when the person dealing with company has noticed whether actual or constructive of irregularity. 2. Suspicion of irregularity. The doctrine in no way rewards those who behave negligently. Where the person dealing with the company is put upon an inquiry, it is the duty of the outsider to make the necessary inquiry. 3. Forgery. The doctrine of indoor management applies only to irregularities which might otherwise affect a transaction, but it cannot apply to forgery as it is nullity.